Let's get straight to what you actually want to know. How much money can I get? The honest answer is, it depends. And I know that's not what you want to hear, but the reason it depends is specific. And once you understand the factors, you'll have a much clearer picture of where your case stands. The two categories of damages in California. Every personal injury claim in California breaks down into two categories: economic damages and non-economic damages. Understanding both is essential to knowing what your case is worth. Economic damages are the concrete, measurable losses. These include your medical bills, emergency room visits, ambulance rides, surgery, physical therapy, prescriptions, and any future medical treatment your doctors say you'll need. They include lost wages, the paychecks you missed while you were recovering, and if your injury prevents you from returning to your same job, the future earning capacity you've lost. They also include property damage, out-of-pocket expenses, and any other costs you can put a receipt on. Non-economic damages are harder to calculate, but often worth more. These include pain and suffering, emotional distress, loss of enjoyment of life, loss of consortium. This impacts your relationship with your spouse and your partner. There's no receipt for waking up at 3 a.m. because your back won't let you sleep. There's no invoice for the fact that you can't pick up your grandchild anymore. But these damages are very real. They're recognized under California law, and they can be the largest part of your settlement. How pain and suffering is actually calculated? There's no official formula in California for calculating pain and suffering, but there are two methods commonly used. The multiplier method takes your total economic damages and multiplies them by a number, typically between 1.5 and 5, depending on the severity of your injuries. So if your medical bills and lost wages total $50,000 and your multiplier is 3, your pain and suffering would be valued at $150,000, making the total case worth $200,000. The per diem method assigns a daily dollar amount to your suffering for each day you were affected. If your injury caused significant pain for 300 days and the per diem rate is $200, that's $60,000 in pain and suffering. Insurance companies will always push for the lowest multiplier or the lowest per diem rate. An experienced attorney will fight for the number that actually reflects what you went through. Real settlement ranges by injury type. Let me give you some real numbers from cases in the Central Valley, not national averages, what I've actually seen in this region. Soft tissue injuries, whiplash, sprains, strains with full recovery, $10,000 to $50,000. These are cases where you're hurt, you do physical therapy for a few months, and you recover fully. The insurance company will fight hard to keep these numbers under $25,000. Moderate injuries with lingering effects, herniated discs without surgery, torn ligaments, fractures that heal with some restrictions, $50,000 to $200,000, $250,000. Roman's case fell in this average. 2 herniated discs, couldn't return to warehouse work, settled for $180,000. Serious injuries requiring surgery, spinal fusion, major orthopedic repairs, internal organ damage, $200,000 to $750,000, maybe $1 million. These cases involve significant medical bills, extended recovery, and often permanent limitations on what you can do physically. Catastrophic injuries, traumatic brain injury, paralysis, amputation, permanent disability, $750,000 to multiple millions. These are life-changing injuries. My firm has covered multi-million-dollar settlements for clients that won't work again, who need lifelong medical care, who lost the ability to live independently. The factors that move the needle on a case value. Several things can increase or decrease what your case is worth beyond just the injury itself. Liability, clarity. If the other driver was 100% at fault, ran a red light, was drunk, rear-ended you, your case is stronger. If there is disputed liability, California's comparative fault rules mean your recovery gets reduced by your percentage of fault. But here's the important part. Even if you were 40 or 50% at fault, you can still recover the remaining 50 to 60%. Don't let the insurance company convince you that partial fault means zero recovery. That's not the case. Treatment gaps. If you waited 2 weeks to see a doctor, the insurance company will argue your injuries aren't that serious. Consistent medical documentation from day one is one of the most important factors in case value. Pre-existing conditions. Insurance companies love to blame your injuries on something that existed before the accident. But California law says that if the insurance aggravated or worsened a pre-existing condition, you're entitled to compensation for that aggravation. A bad back that was manageable before the accident now requires surgery, that's compensable. Social media. I've seen adjusters pull Facebook photos of clients at birthday parties, barbecues, or out walking the dog and use them to argue the person isn't really hurt. One moment captured out of context can cost you tens of thousands of dollars. Insurance policy limits. Here's the uncomfortable truth. If the at-fault driver only has $15,000 in liability coverage, which is, well, it was California's legal minimum, there may be a ceiling on what you can recover from their policy, regardless of how serious your injuries are. That is why your own underinsured motorist coverage matters. If you have UM or UIM coverage, it can cover the gap between the other driver's policy and your actual damages. The at-fault driver's ability to pay. In some cases, particularly commercial vehicle or trucking accidents, the at-fault party has a large insurance policy or significant assets. These cases tend to settle for more because there's more money available and the insurance company knows a jury could award even more. Why the first offer is almost never the right offer. Insurance companies make their first offer based on what they think you'll accept, not what your case is worth. They're betting you don't know the real numbers. They're betting you need money now and can't afford to wait. They're betting you won't hire a lawyer. That $4,500 offer they made Roman, it was based on a quick medical bill review and the assumption he signed the release before discovering the herniated discs. The real value of his case was 40 times higher. If you've been offered a number and you're not sure if it's fair, ask yourself these questions. Do I know the full extent of my injuries yet? Have I finished all my medical treatment? Do I understand my future medical needs? Have I calculated my lost earning capacity? Have I accounted for my pain, my suffering? If you can't answer yes to all of those, it's too early to settle. Next, watch my video on 10 tricks insurance companies use to reduce your California settlement, because knowing their playbook is the best way to protect your claim's value. If you've been in an accident and want to know what your case might be worth, visit callegal.com or call me, Attorney David Milligan, for a free consultation. Talk soon.